Good morning. In fact, officially, good afternoon. It's grey, it's London, it's Monday. England are through to the quarterfinals. So let's hope that's the perfect launch for this webinar. I have four eager counsel ready to talk to you about the amendments to the JCT 2024. Camilla, David, Hannah, and Ruth. We've got a lot to cover. Most important thing is that you know this. We have a Q&A. Please put your questions as they occur to you in the box. I'm here to sort through them. We'll try and take some of them during the presentation. We might have a little bit of time at the end to cover them, but huge amount to cover, 10 topics and a bonus one. So let's start straight away. And I think that what we've got is we have Ruth first up to tell us topic number one, what's been released, what's to come.
Thanks, Marion. So the JCT have released updated contracts over the past few months. I'm aware some of our viewers will have read some of them and they mightn't have read other parts, so it's a helpful session for everyone. On the 17th of April 2024, we saw the long-awaited publication of the first in the JCT updated suite of contracts. So that's the new Design and Build 2024 and the new Design and Build Subcontract 2024 standard forms. Those logging on will know that these are very commonly used standard form contracts. And I think it's fair to say they're really permeating a lot of the discussion we're going to have today. So that's one of the big updates. In terms of what we see in that JCT Design and Build 2024, it was the first major update since 2016. I think also fair to say a lot more changes than we saw when we moved from the 2016 from 2011 version, no doubt motivated by everything that's happened in the intervening years. So COVID, the construction industry being forced to navigate industry-wide shortages, and of course, building safety, which I know we're going to come on to. So all of the updates very much reflect those events as well. The next update that we had was the 2024 edition of the Minor Works Building Contract family. So that was released on the 15th of May, 2024. And the final thing, we just got this update last week, was that the JCT announced that they will now release the 2024 edition of the Intermediate Building Contract family on the 10th of July. So lots being released and more to come as well.
Well, that gives us a start. More to come, Hannah. Where have we got to on topic number two, good faith?
Thank you, Marion. Article 3 has now included an express obligation to collaborate in good faith. So it requires that parties work with each other and other project team members in a cooperative and collaborative manner, in good faith and in a spirit of trust and respect. Wouldn't we all like that to happen? Further, each shall support collaborative behaviour and critically address behaviour which is not collaborative. So while such an obligation existed in the DB 2016 as a supplemental provision, the decision to promote it to a core mandatory article is a significant change in this edition. The inclusion of this mandatory new clause reflects the growing importance of collaborative working in the industry and is a direct response to the construction playbook. Comparatively, and when compared with other contracts, the equivalent NEC provision, which is contained in clause 10.1 of NEC 3 and clause 10.2 of NEC 4, is typically expressed in much shorter terms, requiring the parties to act in a spirit of mutual trust and cooperation. The case law that we do have concerning NEC suggests that such clauses aren't necessarily futile and may have practical application and teeth. However, there are differences between the NEC form and the new JCT Article 3. And first, the JCT goes further and also requires that the parties are to work with each other in a cooperative and collaborative manner and in a spirit of trust and respect. It will be interesting to see whether these additional requirements give rise to additional obligations or they simply reinforce the good faith obligation. It may be that practically there's little difference. For example, conduct that falls foul of acting in a cooperative and collaborative manner would also probably be considered falling foul of good faith. The second key point is that the JCT imposes this additional obligation to support collaborative behaviours and also address non-collaborative behaviour. It will again be interesting to see whether this is interpreted narrowly or widely and what steps a party will be expected to address non-collaborative behaviours. For example, that could range on one end to providing training on collaborative working to the nuclear option of complete removal from the project. Context will be key in raising such arguments. In terms of practical tips, this new article is a catch-all provision and is only likely to be deployed by parties where there's no other express provision that they can rely upon. Whichever way you look at it, the inclusion of good faith on a mandatory footing should be seen as a positive development and encouraged by users of the JCT.
Thanks, Hannah. Am I the only person on this call who finds the description collaborative behaviour redolent of history? It remains to be seen what that is going to be held to mean. David, you've chosen obviously a topic that plays to your great knowledge and strength on this issue. Topic number 3, building safety. Over you go.
Well, Marion, JCT has been criticised for not giving sufficient consideration to the new procurement contracting framework that the Building Safety Act 2022 provides, but also the new culture that the construction industry is supposed to adopt following the Hackett report. So in particular, you're going to find no set of clauses to accompany JCT DB 2024 for high risk buildings. What we have instead is a very light touch to the JCT 2024 form. The Building Safety Act 2022 amended Building Act 1984 and in particular Building Regulations 2010 to create a new regime for duty regulations 2010, and that new regime applies to all projects where the building regulations apply, not only high risk buildings. Now, JCT DB 2024 addresses this new duty holder regime, as well as amendments to the Defective Premises Act 1972, but it's adopted a very light touch in doing so. So we have a new Article 7, so you have to identify the principal contractor and the principal designer under Building Regulations 2010, but says nothing about what they're supposed to actually do. That's left to the regulations themselves. You have a clause 2.7.2, which makes the employer obliged to comply with Regulation 11A of the Building Regulations 2010 in terms of competence. But again, there's no content to it. It just simply says you have to do it. You have a very, very light amendment to clauses 2.17.2 and 2.12.3 to reflect the new Section 2A of the Defective Premises Act 1972 to include a reference to work in relation to a dwelling, so not just conversion or creation of a new dwelling. And where you see in clause 3.16 previous references to the CDM regulations, that now extends to Part 2A of Building Regulations 2010. And this, in my opinion, is actually rather dangerous because it suggests that you can elide those two regimes, where in fact, although they're complementary, they're not identical. They're comparable changes in the minor works form. But all this means is if you're going to be building a higher risk building, you're going to have to produce a whole new range of bespoke amendments to your JCT form to deal with golden thread requirements, change control applications, and the new gateway regime. This is all deliberate. JCT published a document explaining that because high-risk buildings are just one type of building, they would not be adopting it or producing any new amendments for it. So I would say it's a missed opportunity to deal with that, and they haven't changed the overall ethos and culture of the form either to deal with Dame Judith Hackett's emphasis on building safety. So I would suggest a missed opportunity when it comes to building safety.
The topics. Well, perhaps not actually. We are going to be discussing some of the other relevant big issues facing anyone on an infrastructure project. But let's take away from this, as you say, the missed opportunity and the need for the bespoke amendments. Now, Ruth, while we're talking about an opportunity to respond to case law and developments in the law, you've got topic number 4, contractors' design liability. What
So
can you tell
Marion,
us?
a bit of a spoiler here with the dates. So we had the 2016 design and build, 2017, we had a big decision from the Supreme Court. So I'd imagine some people at the JCT didn't appreciate that timing, but it is reflected in the contractor's design requirements. So significant changes to the wording of that clauses. By way of a little bit of background, the changes that we see here now reflect the standard amendment a lot of practitioners would make. So if one looks at the 2024 edition, it now limits the contractor's liability in relation to design to no greater than the use of reasonable care and skill. And so the headline point is that unless you're required by statute, the contractor will have no liability for any design to be fit for purpose. Now, Marion, you foreshadowed what that was about. There are a couple of reasons why that change was made, but amongst the industry, there's an understanding that first, it was driven by the contractor market and also driven by a reaction to the Supreme Court decision that many of our listeners will be aware of, and that's the 2017 Supreme Court decision in MT Hogarth. And so the updates very much offer contractors perhaps a bit more of a degree of certainty over their potential risk exposure. In terms of that concern, it was really twofold. So contractors had been held liable for breaching fitness for purpose obligations contained in technical specification documents that the courts decided weren't qualified by the reasonable skill and care clauses set out in the D&B Contract 2016 form. And so in effect, what that meant was the courts were applying a higher standard. And really the difficulty became twofold. First was that contractors faced the risk of having to meet that higher standard effectively of designing not only for reasonable care and skill, but for a fitness for purpose obligation. And the second point, and really kind of went on from that, was that they had a difficulty then in providing professional indemnity insurance to cover that risk. And so the effect of all of that, and I think it's really a theme when one looks at many of these amendments, is that this was a change actually that many parties were already insisting was going to be put into the contract. A lot of contractors would have insisted that the fitness for purpose obligation be removed and be replaced by provisions which look, I think, fairly similar to what we now see at clause 2.17.1.2, but certainly it makes it clear that was a market practice. So when we look at clause 2.17 now, which deals with contractors' liability in respect of design, it's been reworked, and the clause now expressly provides that the contractor is not subject to any duty that its design shall be fit for purpose. And instead, the 2024 form provides that the contractor shall have no greater duty than to exercise reasonable skill and care in its design. Now, if one reads that entire clause, which I won't do now in the interest of time, I think it's fair to say that the first section looks very much like the previous 2016 version, but it's really that second subclause that looks quite different. And it says, to the extent permitted by the statutory requirements, the contractor shall have no greater duty, obligation, or liability than to exercise reasonable skill and care as provided for in the above clause in respect of such design, and under no circumstances shall the contractor be subject to any duty, obligation, or liability which requires that any such design shall be fit for purpose. So pretty clear wording there, but I think it's worth flagging that it is caveated by that important update at the start of the subclause, that to the extent permitted by statutory requirements. So first off, it's not a complete release for contractors. I think that's important to say. But the second point, I think, is thinking about what that will mean in the context of an individual project. David has talked about there, of course, building safety, very much an important theme, also one very much where there are increasing statutory regimes and regulations and very much an evolving, moving landscape. So I think that would be one takeaway I would ask listeners to think about, would be think about not only the contracts you're entering into now and what this clause looks like, but we're going to have to stay abreast of those statutory developments that take place over time because they very much intersect with this clause, and it might be the parties need to think about how they limit or expand that wording appropriately. And the final point, Marion, just to flag, it's not a change, but it's an important point, is that the updated JCT retains the optional provision in the contract particulars for an overall cap on the contractor's liability for loss of use, loss of profits, and other consequential loss arising from any inadequacy in the contractor's design. So again, something for all parties to be aware of. And I think, again, encouraging people to think about, use these standard forms, but apply some thinking to how they're going to apply to your individual project as well.
Well, let's stay with you for topic number 5, which is relevant events and relevant matters, which I think you're going to takes us into, first time we've used the word COVID.
Yes, Marion, I think I might have said it just once earlier, so I might have just won that lottery ticket with the mention just before you, but certainly we haven't mentioned it too much. So if we look at the contract, this is going to be touched off later by Hannah and David. Some really important points here. Relevant events are dealt with at clause 2.26. Relevant matters are dealt with at clause 4.21. As a summary, there have been updates to the definition of relevant events, and it acknowledges, I think, again, a market practice that parties weren't relying on the general applicability of force majeure, and instead they were already starting to encourage and use bespoke drafting to provide for pandemics and epidemics that could arise to constitute a relevant event. So in many ways, Marion, another example of the JCT reflecting the changes or amendments that were already being incorporated in practice. I think it's worth noting the wording of clause 2.26.8 on relevant events. There's 3 subsections essentially there, but it talks about relevant events in terms of 1, the passing into law of any statute, statutory instruments, or subordinate legislation. Again, we're seeing this emphasis on these parallel legal developments that can happen alongside your contract, the exercise of any statutory power, and finally the publication of any guidance. And there's a clarifying point at the bottom where it says that that applies to guidance by the United Kingdom government or any of the devolved administrations, any local or public authority, or any equivalent authority governed by public law. And finally, it says in the case of guidance by the Construction Leadership Council or its successor. I'll come back to that. Now, Marion, again, as you foreshadowed, this all presumably ties back to COVID concerns. There's an optional entry in the contract particulars to select whether these are relevant matters, which would entitle the contractor to loss and expense. And it's also worth noting that epidemic and the exercise of statutory powers grounds can also trigger the right for either party to terminate. A couple of points it's worth delving into. The new epidemic relevant event has been included, as has the statutory powers relevant events. They both expanded that. But when one looks at that, I think it might be considered slightly surprising that so much attention has been spent on epidemics, given the height of the COVID-19 was 4 years ago now, and the last time a global pandemic happened was in 1919. So although the JCT's view outlined in its launch event was that more epidemics are likely to happen, I think it probably is an example of quite a narrow focus in the JCT. But I also think, having said that, there isn't a definition of epidemic. And I think, again, this shows an example of these contracts or these standard forms should make parties think about where the risk and liability lies between parties. But one can't assume that they're all encompassing. I think the lack of a definition on epidemic is a good example of that. The second one to come back to, and again, it ties into, Marion, what I was saying before on statutory powers. So I think that's going to be very useful for building safety. I know Camilla is going to talk about sustainability and net zero. Again, something where we don't have a huge amount of regulation at the moment or statutory powers, but certainly one where certain parts of the industry are calling for that. So the CLC is specifically mentioned in the clause. It might be something that could be quite narrow depending on the circumstances. So again, building safety, you often see important guidance coming from the BSR, the HSE, or the Construction Industry Council. Again, not groups that are mentioned, but parties might think about what is the purpose of this project and how might we have to amend this standard form in a sensible way. And the final point, Marion, that's worth flagging is that the JCT has expanded the provisions in clause 3.15. So again, worth looking at. Those sections used to deal with the discovery of antiquities on site. Now it also addresses the discovery of asbestos, contaminated land, and unexploded ordnances. Depending on the projects, these might be more or less relevant. But the effect of all that is that where a contractor discovers any of those ground conditions during construction, they're required to leave it undisturbed and to notify the employer, and the employer then issues an instruction setting out what action they require on the contractor to take. And that is going to constitute a relevant matter. So lots of important points to deal with there, Marion, but I think as well, lots of food for thought in terms of how parties adapt these contracts on the basis of these changes.
Thanks. Now we've reached the halfway mark. No questions have come in yet. Do please put them in. And while they're flooding in, Camilla, I think I go over to you now for topic number 6. And you're going to take a short one first, professional indemnity insurance, a subject close to everyone's hearts.
Thank you, Marion. This is a short one first. So in the JCT 2024 design and build contract, there is now space in the contract particulars to set out specific exclusions or types of sublimits. So the limit on the amount of coverage for a specific type of loss within the overall level of the professional indemnity insurance cover. And this is a change to what was previously included, where it was assumed that the only sublimits which applied were in relation to pollution and contamination. And this change reflects the market where insurance for claims in relation to, for example, cladding or fire safety can be offered as a sublimit.
Well, neat, small and important to everybody probably on this call and who advises in this area. Now let's go to your seventh topic, sustainability and environment. It could not be bigger. What does the JCT divisions do for us?
Well, let's have a look at what changes have been made. So as Ruth and you have pointed out already, the last suite of contracts was published in 2016. So it almost goes without saying that in the intervening 8 years, the construction industry has become increasingly aware of its impact on the climate, as well as the opportunities that are inherent in the transformation of this sector. So just looking at the JCT's aims in this area, the very helpful JCT Design and Build Contract Guide 2024 explains that it's placed a greater emphasis on sustainable development and environmental considerations in order to do two things: in order to reflect key industry focus areas and as part of its response to the construction playbook. So it's done this mainly by bringing into the main text two previously optional provisions, so making them mandatory and reflecting the shift, as I mentioned, in the sector's approach to sustainability. So turning first to the new clause 2.1.5, the JCT has moved the previously optional supplemental provision 8.1, which was designed to promote positive environmental performance, into a mandatory provision within the main text. So to read clause 2.1.5 in full, it says this: the contractor is encouraged to suggest economically viable amendments to the works, which, if instructed as a change, may result in an improvement in environmental performance and sustainability in the carrying out of the works or of the completed works, and a reduction in environmental impact, provided that no instruction shall extend the contractor's obligations in relation to design under this contract. So, as well as making this clause mandatory, there's been a broadening here. And whereas supplemental provision 8.1 only referred to amendments which may result in improvement in environmental performance, clause 2.1.5 adds to the amendments which are encouraged, and those are improvements in sustainability and also a reduction in environmental impact. This clause also now provides that no instruction shall extend the contractor's design obligations. So this is important if, in a case, it's envisaged that the contractor will be responsible for all design, including that in the employer's requirements. So parties may wish to consider revising the clause to provide more clarity that a contract will also take on all design responsibility to any changes instructed as a result of the suggested amendments. Now, this clause is interesting because the contractor is encouraged to suggest the economically viable amendments, but not required. So this clause doesn't contain a carrot or a stick to encourage compliance. Turning to new clause 2.2.2. So this again makes mandatory the previously optional supplemental provision 8.2. So it brings it into the main contract and makes it mandatory. And it states as follows: the contractor shall provide to the employer all information that the employer reasonably requests regarding the environmental impact of the supply and use of materials and goods which the contractor selects. So the obligation under clause 2.2.2 to provide the employer with all the information that he reasonably requests regarding the environmental impact of the supply and use of the materials and goods only arises when the employer requests it. So the implementation of this in practice will depend entirely on the employer's appetite. Now, Ruth, you and I have discussed what the intention was behind making these changes, and it'd be interesting to hear your views on the intention.
Well, I think it's interesting, Camilla. I know we've had a lot of discussions with people around sustainability and the climate and net zero. It's obviously very much driven by two things, I think. First, a desire for people to be more ambitious in their projects, not just for net zero because of the benefits of their project. But the second point is, of course, because there will be statutory developments over time. In terms of why these changes might have been made, the JCT hosted a webinar in which its intentions behind the amendments were discussed, and specifically these amendments. As you said, the changes were to bring the contracts more in line with the construction playbook, as well as that industry focus that I've mentioned there as well. So the JCT explained that they had done a thorough review of the existing JCT contracts, and it was decided that they did comply with the construction playbook's theme. So that's an important point in terms of the JCT's conclusions on its contract. But they also said that there could have been greater emphasis on these clauses. So I think that's why we see the same wording, but effectively brought up into the main part of the contract. So there's that emphasis and importance placed on sustainability. But I also think it's interesting that that's what the background was to the decision. We don't see much, I would say, kind of revolution as much as evolution in terms of these. Now, I know we've had a question, Marion, come in on what is the construction playbook. So it effectively lays out what is that road to net zero for the construction industry? How are we going to achieve these aims? It does reflect a lot of industry standard and norms that's developing over time. But I think it's fair to say that a lot of these innovations that we see in terms of net zero, they tend to be very innovation driven by the contractor. They're at the cutting edge of contractor technology and innovation. And so that's that really important point that Camilla brought out there in terms of the carrot and stick approach. So that's just dealing with that. But I think there's this other point that came into the JCT amendment, which was that they didn't want to burden the construction industry by having something totally new. And that's why they use the construction playbook effectively as their anchor in terms of the changes they're going to make. Now, there's been some commentary on that approach. Some have found it frustrating that the drafting has remained essentially the same, that contractors only encouraged to propose amendments. And other people, of course, have pointed out that they don't want net zero to become something that becomes essentially too much of a stick for contractors. They still want to encourage that innovation. But again, I think it's interesting that it's not a hugely detailed clause. It isn't something like NEC option X29 that we see. I think that gives a good detail, level of the detail that would be required. And so the question then, Camilla, I think looking at it is, what are the teeth going to be behind these provisions? Or how can someone make these clauses more meaningful, perhaps by making amendments where appropriate?
You're right, Ruth. I think there will have to be bespoke amendments made as appropriate. And there are no specific environmental related KPIs or climate related targets within the contract, but the JCT suite of contracts does include supplemental provision 7, which states that the employer shall monitor and assess the contractor's performance by reference to any performance indicators stated or identified in the contract documents. So there's an opportunity to make bespoke, an opportunity and perhaps a necessity to make bespoke amendments. Now, just to look at further reflections on the changes, in addition to what Ruth's already set out, there are some startling statistics surrounding the environmental impact of the construction sector. I think these are well known, but just to reiterate what many of our listeners probably already know. According to the UK Green Building Council, the built environment sector contributes to 21% of global greenhouse gas emissions, 25% of the UK's greenhouse gas emissions. More than 4 billion tonnes of cement are produced annually, which contributes to approximately 8% of global carbon emissions. And the UN Environment Programme's Global Status Report for Buildings and Construction, published in March this year, reported that in 2022, buildings were responsible for 34% of global energy demand and 37% of energy and process-related CO2 emissions. So, taking a step back, one might consider whether these changes made are sufficient to drive the change that may be needed to meet the challenges of sustainability, the challenges of scarce resources, and the challenges of reaching net zero targets, which the industry is currently facing. As you say, Ruth, making the existing relevant provisions mandatory is a step in the right direction, but it remains to be seen if they contribute to a real transformation in the industry.
Thanks. It's not surprising that this has prompted a question. In relation to clause 2.1.5, can you clarify, I think Ruth, you're probably best up for this one, if the contractors are required to demonstrate how the change improves sustainability or a reduction in environmental impact, and whether or not there are any liability issues with this that might need to be considered.
So Marion, I think the important point is that if the contractor proposes a change, they are going to have to explain to the employer how is that going to work. And that's a real practical issue that arises in the context of net zero and sustainability, particularly when contractors make suggestions as the contract is ongoing. So I think the first question the contractor needs to ask themselves is, how does this change fit with the overall project, and are there any knock-on effects? If they decide that the change has a benefit and the test that's laid out in the clauses that it's economically viable, they then need to ask themselves, how am I going to evidence this? Now, I would encourage people to look at resources like the UK Green Building Council that have a lot of training for contractors on how they can do things like, let's say, have carbon budgets or assess energy efficiency savings. But I think those are the kind of points, just thinking about this question, having just been answered it, I think that there are going to be issues around energy savings, sustainability and net zero, and thinking, how am I going to evidence these points? Now, the second point that understandably comes up is, what are the liability concerns around that? Now, the first is thinking about, how is this change going to work with the rest of the project? That's why I asked that. There's no point in suggesting something that would make a great carbon saving if the building isn't going to be functional. Of course, a building that didn't have any energy output would, of course, not be producing much carbon in that sense, but it wouldn't be very useful. So you need to think about, how is this going to work with the rest of the project? And the second point then is thinking about, how does your contract work? So I know Camilla highlighted there, some contracts might then tie this kind of clause to something like a KPI or even a low performance indicator if a contractor doesn't put forward certain suggestions in terms of making it more viable. So think about, what other clauses is it going to interact with? How do I evidence my claim? And are there any caveats I need to put forward to the employer so they understand the risk with the approach?
I was just, in fact, looking back at the wording of 2.1.5, and the changes are small, aren't they? You're encouraged to suggest economically viable amendments that may result in an improvement in environmental performance and sustainability. So the thrust of the question being that you've got to demonstrate that it must, I think legally may not be right, although commercially, if you actually want to go ahead and do it, I'm sure you will have to. Let's move on. I think, David, question number 8, topic number 8, the big one, extensions of time. Ruth's already given us an intro. You, I think, have more to add.
Well, Marion, I wish it was a big one. I wish, when I look back at the JCT 2005 form compared to the JCT 2024 form, I could see a huge movement. I can't. It's a very classic formulation of wording, and in particular, our usual bugbears are there. July 2023, JCT flagged they'll be making changes to the extensions of time provisions in JCT 2016. They said there'll be new relevant events and enlarging, as we've heard, the scope of relevant events to deal with antiquities, and a reduction in time for the employer to assess an interim extension of time. And you think, that's a good start. But what about the usual weasel word, forthwith, that you see in the JCT form? I haven't gone back to the 1948 form, but I'm sure it's in there somewhere. Depressingly, it's still there, the word forthwith. So all of the stuff we see in the SCL Delay and Disruption Protocol 2nd edition, how contractors should not store up and save up extensions of time, it's very difficult for me to see why you can't continue to do that. The only obligation on contractors to give a notice of delay under clause 2.24 remains vague. It's required to give a notice forthwith if and whenever it becomes reasonably apparent that work is being or is likely to be delayed, and there's no express sanction if they don't provide a prompt notice. Now, compare that to see what we've seen in the FIDIC family, in the NEC family. Now, I've had a look at the minor works form. That retains what I might politely call its own slimline procedure. I find it very difficult indeed to see what's happened there. So the usual problems of contract management, which I say is one of the weaknesses of JCT, remain extant, which of course means if you introduce bespoke amendments, it's going to adjust the balance of the form overall and the balance between the contractor and the employer, which is exactly what JCT was established to avoid. Now, we've discussed the new relevant events, and I have to echo what's been said before. It's quite difficult to see how this is going to make a material difference to how we operate these contracts. So, epidemics, no real definition for epidemics, but they must affect availability or use of labour or persons providing services, or delaying contractors securing goods, materials, or services. So again, we're pushed back onto the contract administrator looking at causation. There are more detailed provisions with respect to changes to the law. They're more detailed because they make it even more vague. They now refer to the publication of any guidance. Well, that's amazing, because any guidance could mean anything at all, and it's something you might be entitled to as extension of time. So again, it gets pushed back onto the contract administrator. Again, the minor works contract still doesn't refer to relevant events. So in terms of time frames, now a clause 2.24.4 of DB form, it says if the employer requires more information about the notification, then the employer has 14 days from the date of notification to ask for this further information. Well, it isn't quite clear what happens. They ask for it 16 days later, or if you take 2 months to respond to it. But anyway, it's in there now, and apparently it's such a big change, it had to be headlined a year ago. The time frame within which the employer must notify the contractor of its decision on delay claim has been reduced from 12 down to 8 weeks. 8 weeks to make a decision on when you should have fully evidenced your claim. That's still an enormous period, so I can see that being amended. And so a period will run from a later of either initial notification, particulars for delay claim, or any response to request for further information requested by the employer. I have to say, must do better when it comes to the next JCT edition, when it comes to extensions of time, Marion.
You're not happy, are you, David?
The worst part of JCT is extensions of time, and we end up amending it and make it hard on one party or the other, and this is another missed opportunity.
Well, let's pause. Hannah, there's a number of questions that have been flying around about good faith. Before we move to our last 2 bullet points, let's just actually pick up on those good faith questions. First one that's come in is, can we see the new good faith obligation restricting the more onerous bespoke amendments and exclusions beloved by some employers? Anyone like to have a go at that one? Perhaps Hannah, David? And we're also being asked, do you think that the new good faith requirements will impact how parties are to approach the making and assessment of interim claims? Any thoughts on that?
Thank you, Marion. I will take a first punt and then leave it to David. But in terms of good faith, it's going to be very fact-sensitive arguments, and courts may prefer to apply it to reinforce existing obligations rather than merely as a standalone obligation. And this is what's been happening in the NEC3 case law that we've seen before the courts. Particularly in Van Ald UK Limited v Dragados UK Limited, that was a decision from 2021, where it was held that clause 10.1, the good faith obligation, operated to prevent a main contractor from reducing the rates payable under an NEC3 subcontract, where emissions were instructed in breach of the contract. So I think we're going to be looking at how it implements and changes existing obligations, as well as how it looks in terms of a standalone obligation. I think the other thing to think about is, how does that operate against existing principles such as estoppel, which may be used alongside good faith to have arguments such as in Mears Limited v Shoreline Housing Partnership. This was a TCC case from 2015, where parties agreed to operate a payment process that didn't comply with the contract, and then one party sought to revert to the contractual process. Estoppel was used there, but that's an example where good faith could be used. So I think it's looking at how the good faith obligation can also supplement existing contractual obligations of the parties.
David?
I mean, I think we've all done huge numbers of disputes under NEC about making an assessment for interim claims where we haven't seen much impact of good faith. I can't see how an adjudicator or a court is going to find that these amendments, which don't go as far, are going to change the express terms of the contract. I completely agree. It's going to be almost the fourth or fifth alternative, somewhere ranking somewhere behind estoppel when it comes to making actual real arguments.
Just after waiver. Yeah, absolutely. Let's go now then to topic number 9. Hannah, any impacts on insolvency, the problem that's constantly with us and particularly now?
Thank you, Marion. So under the JCT contracts, we know that the contractor and the employer both have a right to terminate the contract on the basis of insolvency of the other party under Section 8. What has changed is that the definition of insolvent under clause 8.1 has now been amended and expanded to reflect the wording of the Corporate Insolvency and Governance Act 2020, which I'm going to refer to as CIGA. So now a company becomes insolvent where first, a moratorium pursuant to Part 1 of the Insolvency Act comes into force with respect to it, or secondly, where an order is made sanctioning a compromise or arrangement pursuant to Part 26A of the Companies Act 2006 with respect to it. So CIGA, which came into force on the 26th of June 2020, has introduced these 2 new restructuring and insolvency procedures that are designed to assist in rescuing financially distressed companies, particularly in light of COVID and the impact that we've seen on the construction sector. And as I say, these are the statutory moratorium process, which you can find in Part A1, and a restructuring plan procedure, which you can find in Part 26A. So clause 8.1 of the 2024 edition now expressly includes these new 2 insolvency procedures under 8.1.4.3 and 8.1.4.4 and has addressed the lacuna created by this new legislation. So therefore, the employer has a contractual right to terminate for insolvency if the contractor enters into a Part A1 moratorium or a Part 26A restructuring plan. Curiously, the JCT 2024 doesn't address other aspects of CIGA 2020. For example, Section 233B, which prevents the contractor from immediately terminating or suspending the performance of its obligations upon the employer's insolvency, as is envisaged in 8.10.1 and 8.10.3. So some changes have been addressed, but not all.
Well, staying with you, Hannah, now topic number 10, you've got 2 here. I'm just going to insist upon calling them both topic number 10, termination and liquidated damages. The connection is obvious. Over to you.
Thank you, Marion, and it is a quite wide topic. I'm going to just cherry pick some categories, particularly in relation to termination first. So to pick up on what Ruth was saying in terms of relevant events, first to look at grounds of termination. So as well as the 2 new grounds for termination for insolvency, the moratorium procedure and the compromise or arrangement procedure, which I've just taken you through, the list of events entitling either party to terminate has also been expanded. So clause 8.11 now includes first, epidemics. As we've realised, this is something that's followed post the COVID-19 pandemic. But the wording isn't just as broad as an epidemic. I mean, we need to look at the wording of the clause quite closely. So it's an epidemic which occurs after the base date or which existed before the base date, but whose effects change after the base date, and which affects the works by limiting the availability of labour or preventing or delaying the contractor in securing goods, materials or services, in each case as is necessary for the properly carrying out of the works. Now, I imagine we're all rubbing our hands and imagining how much we can argue in that clause, but as I say, it's quite caveated and one needs to pay attention to the express wording there. Similarly, as Ruth mentioned, changes in the law is also now added as a ground for termination. Similarly, it is quite caveated. So it says any change in law, publication of guidance, or the exercise of any statutory power by the UK government, any local authority, or in the case of guidance, the Construction Leadership Council, which affects the execution of the works. So this is much broader wording than we've seen before, and it replaces the existing termination event of the exercise of a statutory power by the UK government or local authority. So those two new grounds for termination should be something that users should be aware of. Now, in terms of payment, Section 8 has been amended to make express provision for the service of the payment notices required by the Housing Grants, Construction and Regeneration Act 1996. The highlight is there's no significant change to the way the final payment following termination is calculated. We can all breathe a sigh of relief. But the changes introduce the procedure and timescales for the termination account, express provision for a due date, final date for payment and pay list notices in respect of the final payment. So just in terms of a highline summary, first there is a new defined term of termination payment and defining the due date for a termination payment, and this has been introduced. The new clause 8.7 clarifies how amounts payable by or to the employer are calculated if the employer completes the works after termination. It's important to note that the 2024 edition sets a stricter timeframe. It now imposes a 2-month due date for the termination payment that is due from one party to the other. Third, clause 8.8 clarifies the 6-month time limit by which the employer must notify the contractor following termination that it wishes to complete the works. The contract is now treated as terminated if no such notice is given, and the employer does not commence making arrangements for the works to be carried out within the 6-month period. The calculation of the termination payment is clarified in these circumstances and its due date for payment. Clause 8.12 clarifies how and when amounts payable are calculated following termination by the contractor or by either party for a neutral event or by the employer under the PCR 2015. And finally, clause 8.13 introduces a separate payment mechanism for amounts that are payable on or after termination, which expressly complies with the payment requirements of the Construction Act. So I would recommend for payment disputes that you go through thoroughly clauses 8.7 to 8.13, just to be up to date with the details.
Okay, we're going to take the last two topics and then there's some questions in the chat box which we will take up. Hannah, sticking with you, triple point, did it have an impact on the JCT drafting committee?
So in essence, it now reflects triple point. That's the short line of it. So there's a new clause 2.29.5, which has been introduced to deal with liquidated damages for delay to the works, and this reflects triple point. So if termination occurs before practical completion, liquidated damages will be charged from the completion date up to the time of termination. And then after termination, liquidated damages cannot be claimed. However, the JCT makes clear other rights and remedies remain. For example, damages incurred by the employer due to the further delay can be claimed as general damages. So whilst it merely reflects the Supreme Court's decision, it brings welcome clarity and clarifies what the industry norm is now.
Right, let's get to our bonus point, which I think, Camilla, you're dealing with, and then we'll delve into the questions.
So this is short and sweet. The new suite of contracts reflects a more inclusive approach and now uses gender neutral language. So replacing phrases such as he shall with it shall, he may with it may, and so on. So this is in order to modernize the suite of contracts.
And of course, when it comes to the bespoke amendments that people make to these contracts, they need to bear that in mind. Now, first question. Question here, I think it's for you, David, which is that presumably changes that may be proposed by the contractor under 2.1.5 environmental performance improvement may then count as major changes under the new BSA regime. And so the employer would be unlikely to instruct them if they could result in a delay to the completion date. There's a lot packed up in that. And you're asked if you have any thoughts. I mean, do you accept that? And do you have any thoughts as to how this could be managed?
Absolutely, and I think it's a real weakness of the new form in that they've tried to use words like encourage, while at the same time not giving any thought to the building high-risk building procedures England regulations 2000 and 23. Clause 2.1.5 encourages contractor to use economically viable alternatives if it results in improvement in environmental performance. Let's take an immediate example. Let's think about insulation. You're going to change the insulation material on a high-risk building because there's a better environmental performance, and all should be good and happy with that. Of course, that change is likely under Part 3 of a high-risk building procedure regulations to be a major change, which means that you're going to have to make an application to the building safety regulator to make that change under Part 3, and you're obliged to make an application, and they can take a long time to consult and think about it. What the JCT doesn't say is who is responsible then for the extra time, the extra money in respect of that application. Even more worryingly, there's nothing in the JCT contract now yet that says if you find something that's a statutory divergence under 215, say you realise that actually instead of being better insulation, you need to install safer insulation. Nothing here that says how you allocate time or money. So that's a real problem. It's a real weakness from a JCT form. How would you get around it? Number one, early contractor involvement. As per the Hackett report, try and get all of these issues dealt with earlier rather than having to deal with it during the contract itself. Number two, a clearer allocation of time and money consequences if you need or if you want to make changes to improve building performance or because you have to improve building performance. FAC 1, for example, would encourage you to think out at an earlier stage into who gets the risk, who gets reward. You're going to have to do this, I think, when you're amending the JCT form from the outset, because it isn't on the standard form, Marion.
David, I wanted to ask you about collaborative working, because I think you may have some views with your building safety background as to what they're going to say that means.
It's very disappointing that we have gone back to the mid-2000s approach with just encouragement and general vague wording. Whereas if you look at more modern forms such as FAC 1, the construction playbook, they encourage contractual procedure to actually encourage better environmental performance, improved safety, and at procurement stage, but throughout the project, you have a series of contractual procedures you have to follow. And JCT simply doesn't reflect the current state-of-the-art thinking about those contractual procedures. It goes back to a very traditional approach to this is an obligation on a party, as opposed to, for example, this is a procedure which the parties have to follow to achieve an outcome in order to arrive at a result, such as, for example, sustainability. It's very difficult to see why or how the party is going to improve sustainability, apart from just general admonishments and encouragements to actually do it. So I think if you are going to amend or use JCT 24 and you're going to be serious about these procedures, you may well want to use it in a series of, for example, FAC 1 pull-off contracts from a framework agreement, or you may have to have a whole set of documentation in the employer's requirements or contractor's proposals in order to deal with it, rather than looking to the standard form. You could easily see a standard form set of plugins in order to achieve what should already be in the standard form contract.
Well, let's go also to one of the other clauses, which is generating a lot of interest. And I think, Ruth, you took us through it. It's clause 2.26.8 and the occurrence of things, I'm going to call it COVID related. Perhaps you can take on the questions that are asking what sort of statutory regime changes we could see in the future and how they're going to be relevant to these clauses.
Thanks, Marion.
And
So we've had a
Sorry,
Yes,
the other question, if you just pick up on this bit, there's another question asking, is this an expansion or is it just expressing the same thing in a more detailed manner?
I think that's a good question, Marion, on is it an expansion? So if one looks at what the wording was under the 2016 version, so that was the exercise after the base rate by the UK government of any local or public authority of any statutory power that's not occasioned by the default of the contractor. And then if we compare that then to what we have in the updated version, Marion, whether we brought everyone through, so that was 2.26.8, that had quite expansive wording. So it has the passing into law of any statute, statutory instruments, or other subordinate legislation, regulation, or bylaw. And it says whether to make a new law or change by repealing an existing law. I think that's quite interesting. Again, that's more expansive. We get the subsection, which is the exercise of any statutory power. That is a lot like the wording that was in the 2016 version, so we can see the similarity there. But then it closes on the publication of any guidance. So Mary, I think the headline point is certainly inspired by the DB 2016, but quite expansive. So when one asks the question of what kind of guidance or statutory power one envisage, I mean, it's a real tea leaf question because it's very broad wording. It could in theory be everything. But I think when one looks at developments that governments normally make, one needs to think about what are the issues that people are very concerned by. Of course, we've seen that with building safety. The concern after Grenfell Tower was what motivated the suite of changes that we've seen to the law. One needs to think about what do people appear to be concerned about now. I would say things like setting carbon budgets, looking at the construction playbook. They're certainly themes of things that people will be concerned about. So to answer those questions briefly, I would say inspired by DB 2016, but certainly an expansive version. What kind of changes could we see? I would say anything that people generally seem to be concerned about that could impact the construction industry, could in theory form the basis for updated guidance or statutory developments.
Well, as you know, I'm rigorous about this. We're right up now against our time limit if we allow for wrapping up. So can I ask each one of you to give our audience a key takeaway from the work that you've been done just starting to dip into JCT 2024? Let's do it in alphabetical order, and I think Camilla, that's you first up.
Thank you, Marion. Well, that has been covered quite extensively during this webinar. For parties wishing to look to make their projects more sustainable, they will probably have to look beyond the standard form.
Okay, David.
If you're contracting in respect of a high-risk building, you must make a number of important amendments to the contract. And in respect of extensions of time, I'm afraid it's going to be business as usual.
Hannah.
Thanks, Marion. So in terms of insolvency and termination, the JCT 2024 helpfully brings in line with recent developments such as the Corporate Insolvency and Governance Act, the inclusion of new termination events post-COVID and triple point. The one to watch may be the development of Article 3 and any differences with the good faith obligation in NEC3.
Ruth.
I would say, Marion, I'll keep banging on this drum, but I think some really interesting developments on clause 2.17 and clause 2.26, how the statutory framework and guidance and issues that people are concerned with sit alongside the construction industry. I think that has always been true, but is increasingly true and is very much reflected in this new JCT 2024 form.
Thank you so much covered. More to come, I'm sure. To our audience, please watch this space. 39 Essex is currently organising our one-day autumn conference. We're planning at the moment 3rd of October. Hold the date. Look forward to seeing you all there. Thank you for joining us. Good afternoon.